Okay, we're just about ready to get started here. All right, and Don, are you ready? Well, ready or not, here we come. Good evening. We call the September 21st meeting of the Lincoln Park Mayor and City Council to order. If everyone would please rise where you're at for the Pledge of Allegiance, which will be immediately followed by the invocation by Reverend Gary Shipling of Blessed Hope Church. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Reverend, whenever you're ready. Hang on, you need to unmute yourself, sir.
Can you hear me now?
Yes, we can. Yes, we can.
Okay, thank you. Dear gracious Heavenly Father, Creator God, we come before you this evening, Lord, seeking your will, not only in our lives, but in the lives of the city and the state, Lord, where we first of all ask for your guidance and your intervention in this time of this virus striking, and Lord, we're seeking your hand and quelling it, putting it down, Lord. Lord, we pray for all those who are within the city council, Lord, and we ask for your guidance for them, that they are doing the will of the city, Lord, and the people that have put them in office. Lord, give them direction. And Heavenly Father, we ask for your blessings on our first responders, Lord, and on those people that are putting themselves in harm's way during this time. And Lord, we pray also for our service people who are away from home and enduring a lot of extra grief, Lord. We ask you for your comfort for them and for their peace. And we do all this in the name of Jesus Christ, our Lord and Savior. Amen.
Amen. Amen. Thank you, Reverend. I would ask also that you keep the family of Ruth Bader Ginsburg, Supreme Court Justice that recently passed. Keep her family in your thoughts and prayers also. A true leader, and a lot of significant cases in which she served on. Okay, we'll now go to roll call.
Council President Brady?
Present on the phone.
Present.
Kelsey?
Present.
Parkinson?
Here.
Ross? Here. Salcido? Carlos is muted.
about 20 buildings, it's homes, it's renovated here. Lincoln Park. The reality is we did meet with them online on August 27th. They agreed and requested to restore the property with the same stipulations that they have a limited time of 6 months. They also have to put an insurance bond on the property if they do not comply with our request, and that it would be transferred. I do not know if anybody is here, Linda or the other gentleman is here tonight to speak on their own behalf, but they've agreed that they would comply. I do now know that from August 27th, Dangerous Building Board meeting, the property has changed hands one more time.
Okay, is the owner of the 552 Emmons on the meeting call?
If not, it again is my recommendation that we give them the 6 months. They are required to put a escrow account bond in the city. Again, this property has the same issue as Champaign. If it does not get renovated, which it should be able to be done inside our standards, it is under a buildable lot size, and if it comes down, our city does not have the ability to put a building back on this property.
May I ask a question through the chair?
Yes, go ahead.
Now this has changed hands again. Is there anything that we can do to prohibit them from selling it again? This is burned out house that has been there, close my house, for 3 years or whatever. So is there anything that restricts them selling it again and again, prolonging this extra 6 months we're giving them?
No, but what we did in this case and all previous cases, this last hearing, is we've made a written document in it that every building that is approved at this hearing or ordered to be renovated, if they sell it, the purchaser of it is held to the same standard who agreed to renovate it is. We didn't change the standard, and they have to hold it, and it has to transfer to the next owner. So the 552 owner that just bought it has the same restricted amount of time or loss of building in the 6 months, even though they transferred the ownership.
Do we have the city attorney that wants to be heard on this also? Go ahead, sir.
Sorry, sir, I'll follow the protocol. It's more difficult under Zoom, but I want to advise council that council does enter an order adopting the recommendations of Mr. Myers. I would recommend that it then be recorded with Register of Deeds. So it'll be a covenant with the land that will expire once they be withdrawn, once they complete the repairs that are required by Mr. Myers.
Okay, is there anyone that in the audience that wants to be heard in reference to the property on 552 Emmons?
Through the chair, Your Honor, are you asking for the owners, or can I chime in?
I was looking for citizens in the audience, but go ahead, sir.
All right, my only concern is after 6 months, the building department might consider a 3-month extension. But like Ms. Breeding said, this has been laying around for 3 years. I don't know why that's in there. So,
well, we'll have
6 months.
We'll have an opportunity as when this goes back to after the public hearing for this resolution to be discussed. So there will be an opportunity at that time for that. Is there any anybody else that wishes to be heard on 552 Emmons? Okay, moving on then to discussion regarding Dangerous Building 422 Farnham. And we have again Mr. Myers.
Again, this is a house that was requested to be finished last summer. It had a fire about 17 months ago. They have already begun renovation and construction of repairs. They have pulled permits, stopped the permits over the winter, and then through the pandemic, it hit the Dangerous Building Board meeting on August 27th again, and they are in agreement that they should put it back together. We've given them 6 months, the same lien of an escrow account for demolition if they do not comply within 6 months of your approval.
And the owner's name is?
Miss Crowe, C-R-O-W-E.
Okay, I don't see her on the call. Is there any comments or discussion from the audience in reference to 422 Farnham?
Yeah, I'm actually a direct neighbor of 422 Farnham.
What's your name, sir?
My name is Francisco.
Okay.
Esparza.
Go ahead.
I appreciate you guys letting me speak here. Yeah, I'm a direct neighbor, and I know there've been work on and off going on in that home. I'm just concerned. It's been about a year and a half. They rarely come out when they do. The construction is done not very well. There's a mess next to it. I basically really can't even open up my windows because of the smell and the rodents that yard's causing with all the wood and mess in the backyard. I voiced my concerns plenty of time to the different construction crews that have showed up there, and they'll occasionally clean up, and then a couple weeks later it kind of goes back to how it was previously, and it's just it's just getting really frustrating. It's about 2 summers that my kids really can't go outside and really play in front of my house because of it, and it's just an eyesore, Council Park, and I just kind of frustrated here. I feel like it hasn't changed hands. Same owners had it. I haven't seen her since the house burnt down, to be honest, and it just feels we feel kind of helpless here, to be totally honest. I'm just not sure if anything can be done to speed up the process, or yeah, again, I'm kind of at a loss of words, not really sure what to do at this point.
Well, we have a process that we have to follow. That's part of it is the public hearing today.
Yes.
We've had Mr. Myers working with that. Sir, can you address those issues that the neighbor has in the upcoming time during the 6 months?
The reality, sir, is he has some of those concerns. The house is now boarded and sheeted. It's getting ready to be roofed. They have windows in place. That was all supposed to be done before last November. They did not. They walked off the job before closing it in last winter. And then come in spring, the pandemic, and they did not operate until May. Their permits expired. We required them to reissue all new permits, and we required them not to get any construction on the inside until we have construction layouts of the safety of the inside. So what we've asked them to do is complete their timeline, and in this last dangerous building, we've required them to understand they have a timeline to get it finished and have occupant capability in it within 6 months, and required to put a lien on it with a escrow account for demolition.
If you could ask or work with the contractors there to have at least maintain their work site.
And we've honored and took response to each of the neighbors' calls and sent someone to follow up within a 24-hour, knowing that this was less than amicable on their part for how they've managed this building.
Okay.
Thank you, I appreciate it.
All right, sir.
Through the chair, Your Honor, if you don't mind.
Yes, sir, go ahead.
2 questions for Mr. Myers. You mentioned 6 months twice. Here it says the owner has 9 months. And how big is the lot size? And has LP Pride been there lately? So 3 questions.
Even if they were there, they would not respond to this as a building code violation without calling us in the second place. So I don't know if they've been there lately. The reality was the conversation by council, by the Dangerous Building Board, felt that the extent of the work may not be able to be done in a 6-month time. I've left it at 6 months because that's what our ordinance of fixing to safe occupancy of a damaged, unfit house would take in our ordinance 14403. So
Last question.
they gave them a 3-month extension if they needed it.
Go ahead, sir. Councilman, go ahead. Okay, apparently, yes, go ahead.
The building manager has stated that they have already been twice now given extra time and told, and they did not finish up on what they were done before. What's to make us think it's going to happen this time?
Nothing?
Well, again, these are things that we can bring up at the regular meeting when we have that as part of a resolution, which will be a little bit later on tonight. And we can either at that time approve the agreement or decide not to. So is there anyone from the public wishing to be heard in reference to 422 Farnham? All right, then we will move on to the next, which is a discussion regarding the dangerous building at 1385 Mill. And again, we have Mr. Myers.
Again, this is a fire damaged late fall last year on Mill Street. It is a property that has taken on a purchaser from the beginning of the pandemic. An owner has purchased it. We've restricted him from building on it, and since it is going through the Dangerous Building Board. He was with us on the Dangerous Building Board meeting of August 27th, and he confirmed that he wanted to put it back into function and operation as a housing. If this house does come down, it is on his lot size too small to rebuild. So the recommendation of the Dangerous Building Board is, again, to follow our code ordinance for finishing renovation and repairing to safety, 1444.3, giving him 6 months, giving him the approval of the council to bring it back to the building department standards, as well as putting an escrow account for a demolition bond.
And the owner's name is, sir?
And I was just looking for it as you spoke, and I'm sorry I don't have it in front of me at the very moment.
Okay, is the owner of 1385 Mill in attendance at the Zoom meeting?
We are.
Okay,
Jason Jones. My name is Jason Jones on behalf of Youth Snapback Housing Nonprofit Corporation.
okay. Mr. Jones, do you have anything to say reference to the Mill Street address?
Other than we are moving forward with the recommendations as requested, we've already engaged the structural engineer and are ready to provide the structural engineering letter suggesting that the structure is viable and need not be demolished, is available for rehabilitation, and our plan is to move forward in that manner.
Okay. Is there anyone that wishes to have make a comment in reference to 1385 Mill? Excuse me. Okay, then we will move on to the next, which is 26560 Outer Drive. So we have discussion regarding dangerous building there. Again, we have Mr. Myers.
Mayor and Council, this is the only building out of the 5 that are on the docket tonight that the Dangerous Building Board recommended by our ordinance that we demolish. It has been damaged by fire. It's been sitting vacant, and based on my inspection and evaluation, I cannot restore this at market value at 50% of the SEV. And so it was recommended to be brought down and demolished at that time. In each of our 3 original scheduled dangerous buildings that this was on, the owners did not get onto the Zoom since August 27th. However, I have heard from the owner of the property, and his concern, conviction, and belief is that they can restore the building, would like to restore the building at this time, but he did not appear on the on the Dangerous Building Board meetings. So that one, he was supposed to be here tonight. He may still be here. His name would be Terry Banks, and he may be in the audience.
Oh, is Mr. Banks on the Zoom call?
He's appeared up there, Your Honor.
He's, I'm sorry?
I saw the name up there before. Well, now it comes up like this.
Okay, once again, is there Mr. Banks?
Your Honor, prior to concluding the hearing, may I have a few moments to question Mr. Myers on this matter?
Yes, sir, go ahead.
Mr. Myers, this is Ed Zelenak. I have a couple of questions to inquire about the premises. Have you done an internal structural inspection?
I have not on that. I have asked the courts for a search warrant to do such an event in the next 72 hours as soon as the judge chooses to grant me a search warrant.
All right, and it's your opinion that this is purely based upon the fact that the premise has been left unprotected and unrepaired since the fire just over 2 years ago, and secondly, that your inspection is based on a visible, independent third-party outside inspection of the premises that came to that figure of valuation.
That is correct.
And Mr. Myers, the next question requires some accounting diligence. Do you have figures present at this time to support the conjecture or the proposition forwarded by the Dangerous Buildings Board that the 50% threshold cannot be met? Other than the fact that there was a visual inspection, has there been any further analysis of what the cost would be to restore that home?
I do not have those in front of me at this moment.
Mr. Myers, it's separate in terms of a parcel, not adjacent to any other residential real estate in Lincoln Park. Is that correct?
That is correct.
It's on, what, an approximately 2 or 3 acre lot that abuts the Ecorse Creek and the fence of the...
I believe it's 1.86.
And it's adjacent to the Vencor Hospital. It's on the east side of the hospital premises.
That is correct.
And it's your understanding from speaking with the fire chief that it's got a sufficient amount of copper heating and structures inside that would be both costly to remove because of the unknown presence of asbestos and other protections in the premises, and secondly, that this home, because it has a historical significance and is perhaps the largest residential home in Lincoln Park, would be a costly demolition.
It would be costly to demo, and it also would be costly to restore because of the type of damage and the type of materials that it was previously built on. And if it was established by the city standards, we wouldn't be able to meet those demands in trying to restore it. And therefore, without response from the owner during their meetings, we brought it to the council for conversation and resolution.
And you have had dialogue with Mr. Banks, haven't you?
I have.
And Mr. Banks has indicated that he thought the ordinance was too restrictive, but at that time you indicated that if he came with a plan and a performance bond which would cover the cost of demolition, you would consider further evaluation of a plan to rehabilitate the home.
I actually offered him the opportunity by sending by our ordinance and the guidelines I would set for him as a parameter from the ordinance 1444.08 again. I sent it to him by certified mail along with an invitation to this meeting. And then I've spoken to him in person and have agreed and confirmed that I've sent to him by email, and he had received it in both counts.
Your Honor, I would make a recommendation to council that you continue this hearing for a reasonable period of time to bring it back up, to make sure Mr. Banks is here. In light of the history of the home, the historical perspective of the home, and the recent adjacent and pertinent matters that appeared before an agency of the state of Michigan, that everything be afforded in terms of due process to Mr. Banks to respond, to see if he can meet the threshold of the cost and the bond to repair this home, because it's not in a neighborhood that is threatening other homes, and it's not to the point where it's completely unsightly as to the picture or the composite of the city of Lincoln Park. It's on the border with the city of Ecorse in southwest Detroit, adjacent to a hospital that's being switched. That a slight continuance to allow Mr. Myers to do an internal inspection pursuant to a search warrant to secure an estimate or an evaluation as to what it would cost to restore the premises if we meet the 50% threshold. Because if there's litigation, I'm not comfortable that we have a sufficient record right now to order it demolished and face an appeal to circuit court.
So you're recommending that we adjourn this or this hearing until the October 5th
That would be
meeting?
fine with me if Mr. Myers, Your Honor, can execute the search warrant. If he can get some figures and if he can take someone in to give an evaluation and a cost estimate of what the cost of repair would be. Because 50% is a subjective test for individuals, and if someone is willing to pay 70%, you can't stop them from rehabilitating the property.
Okay, and what action do we need to do in order to...
Subject to counsel, I would ask to continue the hearing for 2 weeks, sine die, whatever they call it in Latin. So, in other words, you're not adjourning the hearing, but you would continue the hearing to the next meeting and renotice Mr. Banks to give him an opportunity to appear, to get in his evidence in time, and to make sure that he receives notice within a week, so he has sufficient time to do what he's supposed to do, to present his position to the council. Because if he's on the board, he's not on the board now, and goodness knows what's happened with Zoom. I don't think the city should risk any potential further appeal on demolition of a structure of that size without affording every step of due process.
Okay.
So that would be just to continue the hearing for 2 weeks. If they have no objection, just close the hearing and declare it continued, or when you
Does,
motion on it, re-notice the hearing for 2 weeks.
Is there an objection to continuation of this hearing until October 5th?
I do not. It'll give me more time to secure a search warrant both for internal inspection as well as any property security that would be valuable to be taken before any danger or damage took place to the building any further.
Okay, and you will make notification to Mr. Banks in the proper fashion?
Each step of the way.
We'll make certain, Your Honor, that if there's any lien holders, banks, or other parties of interest, we'll notify them. And we'll present it the next time for the council, the state of the taxation payments on the property, if there's anything in arrears or danger of forfeiture or foreclosure.
Yes, we want to do things the right way, so this hearing will be...
Mayor, I ask one more request. It's been brought to my attention that because of this concern of taking down someone's house, and we haven't, we've tried to restore most of them in this period of time, but it has been suggested that maybe we double back and make sure we have a new title search and verify all parties involved in owning this property besides one.
That's right.
Okay, are you going to be able to have that completed by October 5th?
I would ask for that kind of exception in contacting. I've already contacted the title search company last week and see where they could do it on a timely manner.
Okay, then this hearing will be continued until October 5th. And
If there's any objections.
again, are there any objections to this being continued? Hearing none, then, I'm sorry?
I was just going to make a comment through the chair. I don't have an objection. My only comment through the chair, if I'm recognized, is that...
Yes, sir, go ahead.
The city attorney, lockstep, they worked as a team to make sure we're in the right process the next time we come in front of the council. In other words, all the T's and I's are crossed, or T's are crossed and I's are dotted, like Mr. Zelnick has said. So that's just my suggestion.
Absolutely.
So if we're due to have a hearing, then they should get together beforehand, before it's presented. Is that what you're saying?
Yes.
Okay.
That's my only comment, sir.
That's a good plan. All right, then that will be continued to October 5th, and we will now reconvene the regular meeting. All right. So whereas the Dangerous Building and Code of Appeals Board issued a decision to modify a demolition order to allow repair or alteration of the building structure located at 1872 Champaign, said order being issued subsequent to a hearing of the facts pertaining to the matter and identified as DBB 2005-1872 Champaign, which was held on August 27, 2020, in accordance with Section 1444.08C of the Codified Ordinances of the City of Lincoln Park. Whereas the Dangerous Building and Code of Appeals Board has filed a report of its finding and a copy of its order with the council, and each party having a recorded interest in the subject property. And whereas the City Council has established the date of September 21, 2020, the date for a hearing to review the findings and order of said board, the owner and party of interest having given the opportunity to show cause why said structure should not be demolished, and the council having duly held such hearing. And now therefore be it resolved that said order of the Dangerous Building and Code of Appeals Board stating that the owner of the structure located at 1872 Champaign, Lincoln Park, Michigan, shall post a cast or surety bond consistent with the building official cost estimate with the City Treasurer's Office within 14 days of City Council's order for a cost of demolition if renovations are not met. The owner has 9 months to complete the required work. All necessary permits shall be pulled with the building department within 14 days of the City Council's decision. This decision runs with the land as a covenant and is hereby ordered by the Council of the City of Lincoln Park. I'll move on this.
I'll support.
Okay, discussion? Clerk, call the roll.
Mayor Carnes,
Yes.
Councilpersons Kelsey,
Yes.
Reading,
Yes.
Higgins,
Yes.
Parkinson,
Yes.
Ross,
Yes.
Salcido.
Yes.
Motion carried.
Okay, the next item, whereas the Dangerous Building and Code of Appeals Board issued a decision to modify a demolition order to allow repair or alterations to the building structure located at 552 Emmons, said order being issued subsequent to a hearing of the facts pertaining to this matter identified as DBB 2003-552 Emmons, which was held on August 27, 2020, in accordance with Section 1444.08C of the Codified Ordinances of the City of Lincoln Park. Whereas the Dangerous Building and Code of Appeals Board has filed a report of its finding and a copy of its order with this council, and with each party having recorded interest in subject property. Whereas the City Council has established the date of September 21, 2020, the date for a hearing to review the findings and order of said board, the owner or party of interest having been given the opportunity to show cause why said structure should not be demolished, and the council having duly held such hearing. Now therefore be it resolved that said order of the Dangerous Building and Code of Appeals Board stating that the owner of the structure located at 552 Emmons, Lincoln Park, Michigan, must post a cast or surety bond per building official cost estimate with City Treasurer's Office within 14 days of City Council's decision for demolishing the building. Owner has 6 months to complete the work. At the end of the 6 months, the building department might consider a 3-month extension. All necessary permits must be pulled with the building department within 14 days of City Council's decision. This decision is hereby approved by the Council of the City of Lincoln Park.
I'll move on this.
Support. Discussion?
Your Honor, through the chair.
Yes, go ahead.
This house has been sitting here for over 3 years. It has been switched back and forth between owners. I believe the owners are playing games with us. That's a personal note. I don't think we should give them any more time. I think this house needs to go. And that's my personal opinion.
Okay.
And
Further?
if I may, through the chair,
Yes, go ahead.
I agree with the councilman, and furthermore, I think we're being too lenient on these properties that have come before the Dangerous Building Board. They have already been notified. They have been given plenty of chances. They've had hearings before. The Dangerous Building Board ordered it demolished, and then it changed hands. I think we're being a little too lenient on some of these properties where they are just changing hands back and forth, and they're just prolonging the action on these homes. That is my opinion, and I will be voting no when it's at the end. That's all.
Okay, further discussion?
Through the chair.
We'll go Councilwoman Ross. Go ahead.
Thank you, Your Honor.
On this one, we don't have the added, if renovations are not met after that, 14 days of city council decision for demolishing the buildings. I think we should add that. The one beforehand.
In what section did that?
Going down on the last, let's see, 1, 2, 3, 4, about 5 lines up from the bottom, where you see 14 days.
Okay, I don't know if I misread, but these appear to be the same.
No. The one beforehand said, within 14 days of city council's order for cost of demolition if renovations are not met. And that's what's missing on this one. The, if renovations are not met.
Okay.
All right, we can, if that's okay with the mover and supporter, I can add that in there.
Thank you.
I support that.
Okay. I'd like to hear from the city attorney here, if he wouldn't mind going up to the microphone.
The language change would be placing a 14-day period for demolition if they didn't meet the requirements?
Well, that's not what I'm asking. But that's what this matter has been. The Dangerous Building has granted it sort of an extension subject to council, correct? And that has been presented that way. Now, if council chooses to vote this down, what is the next step in the process?
Council will need objective criteria to order the demolition, or it'll go back to the Dangerous Buildings Board in most likely premises, because there isn't sufficient evidence, in my opinion, presented to council to show the building needs to be demolished and it doesn't meet the requirements of the code. Notwithstanding council's concerns about what seems to be playing three-card monte with the property, in my opinion, there's not enough evidence. If there were an appeal, it would be sent back for rehearing. So if council's not happy and they're going to vote this down, the next resolution should be to send it back to the Dangerous Buildings Board to consider demolition. I'm not being mic'd? Okay.
Thank you. Oh. Did everyone receive that? Did they hear that?
I'll repeat that, Your Honor, if they haven't.
Go ahead and repeat it.
If they've heard me before, it means I have an awfully loud mouth, because this hasn't been on all night. Members of the council, if you elect not to extend the period as recommended by the Code of Dangerous Buildings Board decision, your prerogative would be, if you feel it should be demolished, to send it back to the board to review it and to see whether it should be demolished based upon the circumstances. I don't believe you have sufficient evidence before you today to present this and make a firm decision that it does not meet the requirements of habitability or rehabilitation. I said earlier that if you think they're playing three-card monte, you placed that on the record here today already, but you need further findings to show that the building cannot be saved in order to order it demolished. You can smack someone in the face, you can paddle them anytime you want, but there has to be measures taken that either fix, repair, or demolish in a certain period of time. If it's your decision that you don't support the recommendation as presented by the building superintendent, I'd recommend that after you vote it down, if you do vote it down, to then pose a resolution and refer it back to the Dangerous Buildings Board for consideration of demolition or other rehabilitative action at its next regular meeting.
And then it would come back.
It would come back to council again, yes.
At some month or two down the...
Exactly. It's just that the case wasn't presented as a building that should come down, and because of that, Your Honor, I'm not comfortable moving forward if it were appealed. If it's not appealed, you're fine.
Okay. Further discussion?
Yeah, through the chair.
Yes, sir. Go ahead.
I have the similar concerns as Councilman Higgins and Council President Breedy. I appreciate what the attorney says, and I have to agree, but how do we get, I guess the question is, how do we make the point or get the fact that we can I guess, tighten the rules to make sure that these people do proceed on a timely basis without, extenuating circumstances, because that house has been sitting there for a long time, and the council originally ordered demolition, and that order has not been rescinded. That's still part of the record, so I don't know what happened to that, but that's still part of the record. And the question I got is the same thing as the other two council people. How do we, I guess what I'm saying is, I understand what the attorney said, but that's just going to send it back to us, and it's going to be the same discussion again. I guess, is there a separate thing we do after we do this and send this on its way that we can talk about doing things differently to make sure that people abide by the rules? I guess is my question, Your Honor.
I have a proposal, Your Honor. In the past, the council has approved resolutions from the Dangerous Building Board that read similar language but add the appendage, fix, repair, or demolish in the same time period. So they're given that time period to fix or repair, or then it goes for demolition. And at that point, if they agree and accede to that, they waive the right of appeal. If you want to append the language or amend the language, however you put it, to add that fix to code or demolish in the time period that Mr. Myers is giving them, the mover and supporter would have to agree to that, but that would be appropriate. It would address your concerns then. And then it's kind of the old cat is out of the bag or the cat's in a bag in the middle of the creek situation for them. I don't want the cat lovers to get mad at me for that
Then
comment.
it could be demolished after the...
After the time period is up, yes. In that point, if they agree to that and sign the agreement with Mr. Myers, they waive the right of appeal.
Okay, someone was beginning to speak.
Well, I was just going to say through the chair that I appreciate Ed's answer to my question. That's what I was...
Okay.
That's what I was looking for.
All right. Is there interest to having that language added to the resolution?
Your Honor, through the chair,
Yes, sir.
I guess this would be a question for Ed. Would it be appropriate at this time for the council to ask the building department to change their recommendation and bring it back to us?
Well, you certainly could do that and get the purported interested party to agree to that, and he could bring a signed agreement to your next meeting and ask you to ratify it, to fix or demolish within that time period, and to post a bond for same, which is essentially what he's agreed to. You get it in writing, and then you've got it all done. And if you want to defer this and ask the clerk to place this on the next agenda, if the mover and supporter will agree to that, you could do that if Mr. Myers can do that in 2 weeks.
I'd like to make that motion. I don't know the wording, proper wording. I'll have to ask the clerk for that. If there's a second out there, to send it back to the building department to bring it back to us.
I'll support that.
Now, there would be an amendment to the resolution. If the mover and supporter will accept it, Your Honor, it would be to refer the resolution for action back to the building department for language clarification for the next agenda.
Okay, and that's amendment to the current resolution.
Yes, Your Honor. And somehow the clerk's going to figure out what I just said there.
Okay, Councilman Higgins, that is your that is your amendment.
Through the chair.
Yep. Yes, ma'am. Let me get the amendment first, and then we had a second.
Yes.
City Clerk, do you have the amendment?
More or less. So by Councilman Higgins, supported by Councilwoman Reading, that this resolution be referred back to the building department for recommendation at the next meeting.
Further recommendation.
Further, sorry.
And an executed agreement by the interested landowner or party of interest.
By the executed landowner, owner, or party of interest?
Yes.
Okay.
Okay.
Councilwoman Ross, you had you wish to be heard?
Your Honor, I guess if we added just those few words of if renovations are not met, how is that not enough for the demolition if they don't comply?
May I answer, Your Honor? My opinion would be based upon the representations of the building superintendent to the landowner's representative. we need further concurrence in writing that if they don't meet that, that there's no more messing around or asking for another extension. It goes up for demolition, and the bond they posted will be utilized for same. And sometimes presenting a consent judgment to council with a contract to meet certain requirements, including the execution of the performance bond, makes it a lot easier and avoids an unnecessary and messy appeal to circuit court. And Councilwoman, the sole reason I'm recommending that is the Dangerous Buildings Board did not find a purpose to demolish, finding that the building met that code requirement. That was not their finding. Their finding was they wanted to give him more time. So you take it beyond that, and you actually kind of put this fellow or woman, whoever's running the property, in manacles or shackles to do what's required in 6 months.
Question is, what's the usual timetable for an appeal to city court?
Well, they've got 21 days to appeal, Your Honor, to circuit court, and the last appeal we had, which is on a zoning matter, we just got our scheduling order last week, about 2 months after the filing of the appeal, so we could easily be 6 months in circuit court, and circuit court could do as they've done in the past, and it's been a long time, send it back to city council to make further findings. And if they do that, you're talking 6, 8 months.
Okay, 8 months, more than likely a year.
Yeah, more likely a year. Yeah, exactly, Your Honor.
Same circumstances where we were before. Okay, so we have a motion to amend on the board. Is there further discussion on the amendment? Okay, then hearing none, then we will now call for a vote on the amendment. City Clerk?
Councilpersons Higgins,
Yes.
Reading,
Yes.
Kelsey,
Yes.
Parkinson,
Yes.
Ross,
Yes.
Salcido,
Yeah.
and Mayor Carnes.
Yes. Now we would then vote on the resolution as amended, correct?
That's right, Your Honor.
All right, then clerk call the roll.
Okay, Mayor Carnes,
Yes.
Councilman Kelsey,
Yes.
Reading,
Yes.
Higgins,
Yes.
Parkinson,
Yes.
Ross,
Yes.
and Salcido.
Yes.
Okay. Thank you, City Attorney, for that. Now what, that was Emmons, right? Okay. Whereas the Dangerous Building and Code Appeals Board issued a decision to modify a demolition order to allow repair or alterations to the building structure located at 422 Farnham, said order being issued subsequent to a hearing of the facts pertaining to this matter and identified as DBB 2004 422 Farnham, which was held on August 27, 2020 in accordance with Section 1444.08C of the Codified Ordinances of the City of Lincoln Park. Whereas the Dangerous Building and Code Appeals Board has filed a report of the findings and a copy of its order with this council, and with each party having recorded interest in subject property. Whereas the City Council has established the date of September 21, 2020, the date for hearing to review the findings and order of said board, the owner or party of interest having been given the opportunity to show cause why said structure should not be demolished, and the council having duly held such hearing. Now therefore be it resolved that said order of the Dangerous Building and Code Appeals Board stating that the owner of the structure located at 422 Farnham, Lincoln Park, Michigan, shall post a cash or surety bond consistent with the building official cost estimate with the City Treasurer's Office within 14 days of the City Council's order for a cost of demolition if renovations are not met. The owner has 9 months to complete the required work. All necessary permits shall be pulled with the building department within 14 days of the City Council's decision. This decision runs with the land as a covenant, is hereby ordered by the Council of the City of Lincoln Park.
Support.
Okay, discussion?
Through the chair, Your Honor.
Yes, sir.
Councilman Salcido, I never get the lot size. What was the lot size on this property?
I understand that it was not buildable, but, Mr. Myers, do you have the,
38.5 feet.
so it is buildable then?
No,
Oh, okay, it's got to be 40 feet.
correct.
Okay.
Thank you.
Your Honor, through the chair.
Yes, sir.
This is a property where, and it's been backed up by the building department and the neighbors. They were given specific orders in the past what to do. They did not do it. They didn't button up the house, so there was more damage done inside over the winter. They have not taken care of their yard, so that the neighbors are complaining because the house, I've walked by several times where there is debris flying all over the place. I cannot possibly vote to give them an extension.
Okay. Further discussion?
Got a quick to the chair.
Yes, sir. Go ahead.
Again, this is one of the problem houses that we've been talking about. How do we, if we get this to be the same as we did the other one on the 552, to make sure that it gets a little bit more looking at, I guess, so we can put this on the track to monitor it better, I guess, based on its history? Or is that not, I mean, that's what I'd like to do. The building, I think the Dangerous Building Board already said, and not to verify Ed, but it's already said that it could be rehabilitated. So I'd like to see it maybe rehabilitated, but also a little bit better overlooked to make sure it continues on its journey and doesn't get stopped the way it's been. And that's what I'm looking for. Some kind of incentive to the construction crew or the person that owns it to move it forward where it's supposed to be. Fix it the right way and get it back where it's supposed to be.
Your Honor, could I speak again?
Well, hang on just a second. Mr. Myers, do you wish to comment on the past two statements?
Yeah, I have no objections to the request. We've now gotten much tighter in our response. We've kind of invited the two neighbors that are there, three of them. Feel free to call when we see them stop working or when we see them creating debris, and then we make a quick phone call to management of the construction company, Renovations, on their behalf. And what we have done then is moved recently, example, one of the construction crews with their trailer chose to use entryway of people's property, block it and have not access to it. So we were able to then call the police department for them to officiate removing of that in someone's driveway. They weren't in the driveway, but they couldn't get someone out of that driveway. So we've moderated that, and I know it's frustrating for the owners of the neighboring houses, but they've been gracious at the same point of making sure I didn't miss a heartbeat every day, every weekend, any nighttime, every morning, if there's something that's going on that they're not satisfied with. And we've done our best to respond to that customer care in that neighborhood along the way since the opening of Pandemic Building, which was May 7th.
So is there anything stronger that we could put inside of the resolution that could assist you in that?
I personally don't think so, unless you want to eliminate the recommendation to go to 9 months and shorten it to 6. There's no real reason. The house is not that terribly large. If they put people on the construction work team on a regular basis, 6 months on a very small 900 square foot or less property, it's probably closer to 845 square foot land of a piece of house. It wouldn't be difficult to accomplish as a contracting that has the resources, the insurance money, and then the ability to renovate the project as they started last September.
Okay, Councilman Higgins?
I would like to ask John, when was the last time he was actually in that residence?
I was in that residence on September the 3rd.
So 3 weeks ago?
I have not seen since they finished the additional side room on it and covered it in, but I was there to stop them from planning any interior structural floor repairs until I have a drawing of the floor layout and the building layout. But I was there then on the request of a neighbor who saw them offloading what looked to them like science engineered flooring and floor joists. So I left my office immediately and went there and discovered and met with the contractor at that point and stopped any work from the inside until the outside was done and permits were pulled for engineering on the inside.
Well, I'd just like to point out that they tried to go around the city They got caught once, but there's no reason to believe they won't do it again.
The chair, if I may.
Yes, sir, go ahead.
John, do you feel that you've got kind of a better understanding with them about what's involved in this house and what's at stake to make sure that the owner, whoever it is, and I forget the person's name, is more in attendance as far as making sure that the crews do what they're supposed to and we don't have these problems in the past or in the future, excuse me?
The answer is no. But I do have a better sense of my responsibility that I may not have administrated as aggressively as I had or could on this particular property over a year and a half ago when I had it in my hands to do so. So I would try to give you a word of hope and confidence that I won't make that mistake in these dangerous buildings again. But I can't suggest that I've heard from the owner. I've heard from many of the contractors that she's hired, but not the owner.
Okay, so you haven't, through the chair, so you haven't actually talked to the owner in recent. Okay. All right. Okay.
All right, further.
Mr. Chair?
Yes, go ahead.
I agree that we should shorten the time. The 9 months is just too much. If we shorten it down
to 6 months?
60, yes.
Okay, is that your amendment?
That's my amendment.
All right. Do we have a second? All right.
Is that change okay with the mover and supporter? That'd be Councilwoman Ross and Councilman Kelsey?
Yes, I'm okay with it.
Yes.
Okay.
Then we can just go ahead and change that on the resolution. We don't have to make a formal amendment to it.
Works for me. All right. Further discussion on this for 422 Farnham.
Yeah, through the chair, Your Honor.
Yes, sir, go ahead.
Final statement. This looks like a prime property to be torn down in the future and split the property. I've seen the house. Looks like it's on a slab. Looks like there's no garage. I'm in favor of this moving it up time frame, and that's all I have.
Okay.
Your Honor, just for clarification, it is not on a slab. It is a full basement under this property.
It is? All right.
All right.
It looked like. That's okay. Thank you.
Very good. Further discussion reference this resolution? Hearing none, then clerk call the roll, please.
Councilpersons Ross?
Yes.
Kelsey?
Yes.
Reading?
Yes.
Higgins?
No.
Parkinson?
Yes.
Salcido?
Yes.
And Mayor Carnes.
Yes. Next item, whereas the Dangerous Building and Code Appeals Board issued a decision to modify a demolition order to allow repair or alterations to the building structure located at 1385 Mill. Said order being issued subsequent to a hearing of the facts pertaining to this matter identified as DBB 20-01, 1385 Mill, which was held on August 27, 2020 in accordance with Section 1444.08C of the Codified Ordinances of the City of Lincoln Park. Whereas the Dangerous Building and Code Appeals Board has filed a report of its finding and a copy of its order with this council and with each party having a recorded interest in the subject property. Whereas the City Council has established the date of September 21, 2020, the date for a hearing to review the findings and order of said board, the owner or party of interest having been given the opportunity to show cause why said structure should not be demolished, and the council having duly held such hearing. Now therefore be it resolved that said order of the Dangerous Building and Code Appeals Board stating that the owner of the structure located at 1385 Mill, Lincoln Park, Michigan shall post a cash or surety bond consistent with the building official cost estimate with the City Treasurer's Office within 14 days of City Council's order for the cost of demolition if renovations are not met. The owner has 6 months to complete the required work. All necessary permits shall be pulled with the building department within 14 days of the City Council's decision. This decision runs with the land as a covenant is hereby ordered by the Council of the City of Lincoln Park. All right.
I'll support.
Discussion? Clerk call the roll.
Councilpersons Ross?
Yes.
Kelsey,
Yes.
Reading,
Yes.
Higgins,
Yes.
Parkinson,
Yes.
Salcido,
Yes.
and Mayor Carnes.
Yes. All right. Getting organized here. The next item, reference 26560 Outer Drive, is continued on to the agenda on the 5th. So we'll move on to the next item, which has a cover letter from our planner, I believe. And in background, has recently come to staff attention that there's an inconsistency between 1224.06 Division of Lots and 1294.32 Schedule of Area Regulations in the City of Lincoln Park Zoning Code. 1224.06 Division of Lots currently requires the resulting minimum lot width of 50 feet after a parcel division, whereas the minimum lot width per 1294.32 Schedule of Area Regulations is depending on the zoning district. So, resolved that an ordinance to amend the municipal code of the City of Lincoln Park by repealing section 1224.06B2 and section 1294.32F and replacing them with a new section 1224.06B2 entitled Division of Lots and new section 1294.32F entitled Schedule of Area Regulations respectively be given its third and final reading and be adopted. The City of Lincoln Park ordains that the Lincoln Park Municipal Code be amended by repealing and replacing section .06B2 of chapter 1224 entitled Division of Lots and section .32F of chapter 1294 entitled Schedule of Area Regulations as follows. 1224.06B2 Division of Lots. 2. A platted lot into not more than 2 parts as separate parcels are divided and combined with an adjacent lot, outlot, acreage, or parts thereof, provided that each of the resulting parcels meets the minimum lot area requirements defined in 1294.32 Schedule of Area Regulations for the zoning district assigned to the parcel at the time of the request, 1294.32F Schedule of Area Regulations. F. The minimum land or lot area shall be 4,000 square feet for the first dwelling unit in a multiple dwelling building, plus 2,000 square feet for each additional dwelling unit therein.
Support.
Okay, discussion? Clerk, call the roll.
Councilperson Higgins? Yes. Higgins?
Yes.
Kelsey?
Yes.
Parkinson?
Yes.
Ross?
Yes.
Salcido?
Yes.
And Mayor Carnes.
Yes. Next item has a cover letter by Leah Dumichel, our city planner, from Beck and Rader. And in information, the City of Lincoln Park Planning Commission has considered to recommend approval of amendments to 1296.01 of the Lincoln Park Zoning Code, site plan review. 1296.01 of the City of Lincoln Park Zoning Code outlines the city's site plan review standards, criteria, processes, and requirements. The proposed amendment and reorganization of 1296.01 simplifies the city's requirements and standards to be more concise and to more clearly define the roles and responsibilities of both the city and the applicants, making the city development review process more transparent. City of Lincoln Park Planning Commission held policy discussions on April 8, 2020, June 17, 2020, and July 8, 2020 to evaluate the best practice review of the site plan review standards in other communities and to evaluate the resulting proposed amendments to 1296.01. Planning Commission held a public hearing on the proposal August 19, 2020, and unanimously voted to recommend the ordinance amendment proposal for 1296.01 as set forth in memo with the same date for adoption. Resolved that an ordinance to amend the municipal code of the city of Lincoln Park by repealing or replacing chapter 1296, section .01, entitled Site Plan Review, be given its first and second reading by title only. The city of Lincoln Park ordains that the Lincoln Park Municipal Code be amended by repealing and replacing section .01 of chapter 1296, entitled Site Plan Review, as follows. Okay. No, you got it. We have a mover.
Support.
Okay, discussion? Okay, clerk, call the roll.
Councilpersons Kelsey,
Yes.
Higgins,
Yes.
Breeding,
Yes.
Parkinson,
Yes.
Ross,
Yes.
Alcido,
Yes.
and Mayor Carnes.
Yes. Okay. All right, we got that on. And that, I think, is just a comparison copy. Okay. So our next item is the sign amendment, correct?
Yes.
Okay. And away we go. Resolved that an ordinance to amend the municipal code of the city of Lincoln Park by removing chapter 1290, section .04B2, entitled Off-Street Parking A Areas, and repealing chapter 1260, section .08B, entitled Definitions, chapter 1276, section .02I1, entitled Neighborhood Business District, chapter 1278, section .02AA1, entitled Municipal Business District, chapter 1292, section .14, entitled Nonconforming Signs, chapter 1294, section .19F4, entitled Temporary Buildings, and chapter 1276, section .27, entitled Signs, be given its first and second reading. The city of Lincoln Park ordains that the Lincoln Park Municipal Code be amended by removing section .04B2 of chapter 1290 and repealing and replacing section .08 of chapter 1260, entitled Definitions, section .02I1 of chapter 1276, section .02AA1 of chapter 1278, section .14 of chapter 1292, and section 19F4 and .27 chapter 1294 as follows. Well, I think that it doesn't say by title, so I need to continue on with this, unfortunately. So 1260.08B definitions, billboard, remove definition. Sign, a device for visual communication that is used to bring the subject to the attention of the public but does not include flags or other insignia of any government, fraternal, or similar organization. A sign includes any device, structure, fixture, or placard which uses words, numbers, figures, graphic designs, logos, or trademarks. Unless otherwise indicated, the definition of sign includes interior and exterior signs which are visible from any public street, sidewalk, alley, park, public property, but not signs which are primarily directed at persons within the premises on which the sign is located. 1276.02 I1 Neighborhood Business District. I, accessory buildings and uses customarily incidental to the principal purposes uses set forth in this section, including 1, signage that conforms with section 1476, sign code, 1278.02 AA1 municipal business district. AA, accessory buildings and uses customary incidental to the principal permitting uses set forth in this section, including 1, signage that conforms with chapter 1476, sign code. 1292.14 non-conforming signs. A, delete. B, all non-conforming signs shall adhere to the standards established in section 1476.07 non-conforming signs of chapter 1476 sign code. 1 to 5, delete. 1294.19F4 temporary buildings. 4. The sign standards provided in section 1476 signs permit signs for temporary uses and seasonal events. A separate non-refundable sign permit fee is required in an amount established and periodically amended by council. The city shall also require an escrow in the amount established by council to cover the cost of removing signs if not removed by the applicant within 1 business day following the event. This escrow account shall be in addition to that listed in paragraph F3 hereof. If the signs are removed as required, the sign escrow account shall be refunded to the applicant. 1294.27 signs. The erection, construction, or alteration of any sign as identified in Chapter 1476 sign code shall be approved by the building superintendent and reviewed for compliance with Chapter 1476 sign code and this zoning code.
So moved.
There you go. Did we have support? I didn't hear. I'm sorry. Okay. Open it up for discussion. Hearing none, then clerk call the roll.
Councilpersons Breeding?
Yes.
Salcido?
Yes.
Higgins?
Yes.
Kelsey?
Yes.
Parkinson?
Yes.
Ross?
Yes.
And Mayor Carnes.
Yes. Okay, next item also has a cover letter from Leo Dumichel, our city planner. And this, in information, the City of Lincoln Park Planning Commission has considered, recommends approval of 2 amendments to the Lincoln Park zoning code regarding waste management, to the site plan requirements in 1296.01 F2M, and 2, adding a section in 1294 provisions relating to all districts outlining trash receptacle and dumpster requirements. And City of Lincoln Park zoning ordinance does not specifically address waste management requirements for development. Issue of waste management have recently come up during site plan review process. For example, a site's conditions may not allow for the placement of a dumpster due to a small parcel size. Furthermore, depending on the site's use and operation may not generate enough waste to warrant a dumpster. Therefore, waste management will vary depending on the site. Regardless, the zoning ordinance should have a clear requirement for trash management so developers know what is expected, and so the city has a legal justification for any requirements. So, resolved that an ordinance to amend the municipal code of the City of Lincoln Park by repealing and replacing Chapter 1296, Section .01 F2M, entitled Site Plan Review, and Chapter 1294, Section .41, entitled Trash Receptacles and Dumpsters, be given its first and second reading. The City of Lincoln Park ordained that the Lincoln Park Municipal Code be repealing and replacing Section .01 F2M of Chapter 1296 entitled Site Plan Review and Section .41 of Chapter 1294 as follows. 1296.01 F2M Waste Management Plan that includes trash receptacle locations and method of screening if applicable. Trash receptacles and dumpsters must conform to the screening standards outlined in 1296.03G, and all trash receptacles and dumpsters must conform to the standards and requirements outlined in 1294.41. 1294.41, trash receptacles and dumpsters. A, no outdoor trash storage area may be in any front yard or any required side yard setback which is adjacent to a street unless there is no alternative as established by the Planning Commission. In no instance may any trash receptacle or dumpster be located within or block a designated parking space. B, any outdoor trash storage area must be limited to normal refuse which is collected on a regular basis and must be maintained in a neat, orderly, and sanitary condition. C, adequate vehicular access must be provided to such containers for truck pickup, either via public alley or vehicular access aisle which does not conflict with the use of off-street parking places or access to nearby principal buildings. D, where vehicular access is restricted due to the space or other constraints, curb cars rather than dumpsters may be permitted by the Planning Commission if it will result in no reduction to the public health, safety, or welfare. E, commercial or residential developments may enter into a shared refuse collection facility agreement with one or more neighboring businesses. A copy of this agreement must be submitted as part of the site plan and must specify the location and maintenance responsibility for shared facilities.
So moved.
Support.
Okay. We have a mover and supporter. Discussion?
Your Honor, if I can through the chair.
Yes, sir.
I'd like to ask, who's going to enforce this, and has this been, has somebody gone through the entire DDA area to see if this is possible? Because I'm picturing a couple places where I don't think this ordinance could be done. Has somebody gone through the entire DDA area and checked it to make sure it's possible?
I do not know. Do we have the planner on the meeting? I don't see. Mr. Myers, are you still with us?
That traveler would have been me, and did I go through most of the DDA? Did I see every address? Did I see the regular complaints? The answer is yes. Could there possibly be one that we could find in the future that does not meet it? There's a possibility, but as I said, there's more with this resolution being considered to meet a large growing problem that we need to fix in the upcoming days. There could very well be that I may have missed potentially one or two properties that are backed up with no parking and no backspace for any outside storage without it being temporary service with a different type of container that has to be put back into the building until a day of delivery pickup.
Okay, this was done to address a concern that the trash wasn't being stored properly and was creating a problem. Is that?
Yes.
I understand the concern, and I absolutely agree something has to be done about it, but I question if we should pass something so we're sure that we can actually do it.
Through the chair,
Yes, ma'am, go ahead.
this is just the first and second reading. In the meantime, before it comes back again, I would suggest that we have people go and check this out, each and every address, to verify, because when it comes up for third and final reading, we could amend it at that time.
Okay.
Through the chair, Your Honor.
That sounds like a good idea. Yes, sir, go ahead.
Yes, just, you know, you gave us a lot of homework this weekend, but I wanted to point something out. And ordinance 1296.03, it's called landscaping standards. That's where they talk about the waste receptacles shall be located, screened with decorative masonry wall of at least 6 feet in height, etc., etc., etc. Why wouldn't that be placed under 1294.41? Because that speaks on waste receptacles, and I believe there's a lot of businesses that does not have that masonry wall to hide the dumpsters. So I know this was a lot of work, but I would like to see that waste receptacle 1296.03 combined where it says trash receptacles and dumpsters rather than landscaping standards, if that makes sense. Mr. Myers, I don't want to comment on that, but we've talked about waste receptacles in the past, but 1296.03 refers to landscaping standards. and then it talks about dumpsters. Right here, we're talking about dumpsters and receptacles, so maybe we need to talk about this or something.
Mr. Myers, you care to comment on this?
There are three subjects on this agenda in the writing of the attempt of the writing. There are many dumpsters inside our city for many years that have no closures in them at all. Whether they were that way under the single owner of a building that has never changed management, ownership, or business, or they've just never been required to accomplish. The second piece is there are many smaller dumpsters, not 4 yards or larger, that are actually sitting on city properties in some of these districts instead of actually sitting on their private properties or being picked up in that regard. And so the means to address them are adequately responsible to this agenda that we're bringing up. And then the third one would be places that don't have site plan capability. It's going to have to come back to the building department under a code, commercial code of where we put dumpsters and trash pickup for these properties that are squeezed inside 3 and 4 buildings and have no parking and have no alley access for it to be picked up as a standardized front-loading dumpster vehicle. So Councilman is correct. These are all 3 major issues that we're trying to take a beginning serious move at making modifications, because we see constant concerns, complaints, and legitimate issues with non-enclosures, dumpsters on non-private property, as well as inability to put facilities in people's properties because of the size of the buildings. And we don't have anything that answers that currently, other than everyone has to have one, and for years everyone hasn't had one.
Okay.
I have another question for John. It just dawned on me, if I may.
Yes, go ahead.
John, this will not affect all the businesses on Southfield that actually still use the alley. The alley is open. Their dumpsters are in the alley. The trash collectors come down the alley and pick up those dumpsters. This would not affect those, would it? Because the majority of them do not have any property that they could move that dumpster to. That's why we've never closed those commercial alleys.
Correct. The concern we have is they're even small, but they're turning them sideways so that a front-loading machine can pick them up. And if we turned them sideways and had a different form of dumpster situation for these customers to come to, we could probably make our alleys emergency accessible instead of having giant dumpsters in the middle of them. I can tell you in the last year we've seen 3 modified businesses on Southfield with those alleys, and we have granted them and we've given them the strong encouragement to use a piece of their parking space that they have along the side of their building, and we would be more willing to lose a parking space than to not have a containment of their trash receptacles in a enclosement off the side at 34.5 degrees so that a large truck can come down that back alley, pick it up, back up, and keep going.
However, some of those do not have parking alongside their property.
That's exactly the concern we're having. There's 3 major subjects, and this is the one. They don't have parking, they don't have anything off to get back to the building, and yet we're trying not to destroy the alley that these large trucks are driving in.
Okay, I'm gonna make a suggestion here with the comments and questions that are coming in. I think we need to have a study session devoted just for this. I recommend that we do that before the next meeting, which would be October 5th, and that we would then also table this until the October 5th meeting.
I agree.
So I guess I am hold it until the October 5th meeting.
Right.
And then I would then like to establish a a study session for October 5th at 6:30 to discuss this ordinance.
I agree.
I guess I'll make that in the form of a motion. There you go.
Support.
Okay. Any discussion as it comes to the study session for this resolution for the next council meeting? Other than John, I would like the city planner to be there as well as yourself.
Well, we'll work out the details for you, sir.
Okay, very good. Further discussion on the study session? Clerk, call the roll.
Mayor Carnes?
Yes.
Councilperson Breeding?
Yes.
Higgins?
Yes.
Kelsey?
Yes.
Parkinson?
Yes.
Ross?
Yes.
And Salcido.
Yes.
Now, I may have gotten ahead of myself. The motion to hold this until October 5th, is there a vote required for that?
That's what we voted on. If you want to vote on holding a study session, we need to put that as the last order of business after we get done with the rest of the action items.
Okay, very good. If you would not, if you wouldn't mind reminding me of that, then
I will do that.
all right, that's a beautiful thing. Then moving on, next item that we have is a cover letter from our Chief of Police, Raymond Waters. Subject area police towing bid, and the Lincoln Park Police Department had put out a bid for the police towing contract. Police Department, we received 3 bids. The one, Gotch & Sons, for $1,474.95. 2, Rusco's Towing, $1,659. 3, Martin's Towing, $1,799. Police Department is requesting that the mayor and council award Gotch & Son the towing contract as provided the lowest bid comes recommended by local municipalities that have similar towing needs and can provide premium equipment for towing services. So the resolution would be be it resolved that Gotch & Sons be awarded the bid for police towing for the Lincoln Park Police Department as they are the lowest and best qualified bidder that meets all of the police department specifications. Be it further resolved that the mayor and city clerk be authorized to execute contract documents. Funds for these services will come from the police department's towing yard lease account 101-305-941.
So moved.
Support.
Okay, we have a mover and supporter opening this up for discussion. I'm going to have Chief Waters speak on this first. Chief?
So we collected all 3 of the bids. We examined them all in great detail. We went to all 3 of the companies, walked through each of their businesses, their yards, met with some of their employees. Gotch came with highly recommended through other cities, municipalities, one of being Melvindale that's a similar, has a similar size, a tow lot that he does oversee. The lot was extremely clean and very orderly. He came highly recommended from Melvindale, Dearborn, and the state police. All of his drivers have had extensive backgrounds done on them and already. They've driven with the Federal Reserve, and they tow for casinos, so they've had to have some type of background to go through all that. And then on top of it is a substantial amount or more records and services over the other bidders. And his overall bid package was lower than any of the other companies.
Through the chair, Your Honor?
Yes, sir. Go ahead.
Hey, just a quick question. Hi, Chief Waters. I want to say, is 500 Southfield still in the mix for the storage lot? If so, is it going to be ready by October 15th?
We're hoping so.
All right.
If I may through the chair,
Yes, ma'am, go ahead.
are we going to be installing new fencing down at 500 Southfield? And if so, how much is that anticipated to cost?
We are looking at the possibility of now of getting everything cleaned up first, and then to see where we're at with security there.
And what is the term of this contract? It does not specify in the resolution. It really should say how long of a term it is.
I assumed it was 2 years. All of them are usually 2 years.
That needs to be added to the resolution there, I believe.
Yes, is that good with the mover and supporter?
Yeah, I don't have a problem.
What's the general language? Is it just 2 years, or is it 2 years with an option to the third, or how have they been? James, what's the wording on the most recent contracts we've had?
I think they've been 2 years with 1 year possible extensions.
I believe that's what the last contract was. I don't remember what this one says. I don't have a copy of it in front of me right this minute.
Okay. So, Chief, what would you recommend on the contract length?
So yeah, I mean, I think we could go with the same as 2 years with the possibility of a 1 year extension.
Option.
With the option.
Of one addition.
Whose option is that, Council President?
No, I mean, that's what it normally says, with the option of.
Okay.
I'm sorry.
Is that good? Is that good with the mover and supporter?
I don't have a problem with it.
Okay, very good. We'll open it up to.
Your Honor, to the chair.
Yes, sir. Go ahead.
I question using that lot before we know it is completely secure. That is the reason we stopped using that lot, if I'm remembering right, was for security reasons, not only for...
We are still using that lot now. We've been using that lot for years.
Okay, with the current, with the new contract, that would 500 would be used specifically for that. The vehicles would not be stored at any other place. Would that be correct?
That's correct.
Okay, then I can see concerns with how the lot is if we're going to be responsible for people's vehicles that are impounded there and for the safety of that. There are definitely improvements that need to be made. Are there plans to have that done?
Yes, there are.
Okay, could you expound on that a little bit, Chief?
We're still working on that to, obviously, it would be at the most minimal impact to the city financially as possible.
Okay, I would probably recommend some type of a camera system or that to, as that is a little bit out of the way. Yes, sir, go ahead. Councilman Kelsey, did you have something?
Just a couple questions. I know I've seen that lot, and there were a lot of old wrecks like all turned burn out that were still sitting in there. And that's right close to a neighborhood. If these cars are going to be towed in at all hours of the night, and the flash, not necessarily the flashes going on, but the trucks going around there, is that going to be a problem with the neighborhood that goes right up to there? I mean, I don't know. I'm just asking. The neighborhood's right next to it.
Well, they would. The vehicles would come in through the main entrance of the DPS yard, so it would be like them coming in for a water main break or the like. The entrance to that would be a little bit, a couple houses away from that. I don't anticipate it being a concern. I mean, obviously, we would reach out to the impound company and have them be mindful that it is a residence that they're near. But I don't really see it being that big of a problem. Go ahead. Who did I interrupt?
I was just asking a question. I got two more quick questions.
Yes, sir. Go ahead.
I know the other city-wide had police radios in them and that. Are we going to dispatch or call these like on if there's an accident, like on their cell phone, or do we call the main office and they dispatch them, or how? Because they're going to be, I think James said I-75 and Schaefer, so they're not really in town, but they're not a long distance away. But I just got a question. Have you worked out how to do the communication with them compared to what we've done in the past?
Yeah, so
okay.
We go after speaking with them. They're going to basically, they will operate like a rover system. So they'll have a truck in the area all the time. When one's taken away, we'll kind of like slip in their spot. And then we believe that it'll be just, the other agencies just call dispatch calls them. They have a 24-hour dispatch center, and they can dispatch them out pretty quickly.
Okay. The other question I got is, I don't know what, if we can put some kind of response time, but if you say they're in the area, they should be pretty quick to respond because they're not going to be that far away. Lincoln Park's not that big, only 5 square miles, so it's not going to be like they got a long distance. So I guess that kind of answers my second question about the response time. I mean, that's the other question I had, but that's all I got, Your Honor.
Okay. Chief, you said that they have Dearborn, Melvindale, and they tow for a couple other different agencies. Is there going to be a problem with them fulfilling our requirements in a timely basis, or do they have enough equipment to do the job, I guess I'm asking?
Yeah, they have, I'm looking, 34 vehicles. 34 vehicles over the other bidders had. They have plenty of trucks and drivers to accommodate.
Okay. Further discussion?
This is Alex from Briscoe's Towing. May I speak, please?
We're just we're holding it open for the council members first, sir. Then I'll open it up to the public in just a little bit.
Thank you.
All right. Further comments from from council? Discussion from council?
Just a last question, if I may, for the chair.
Yep. Go ahead.
We're actually going to own them. Obviously, the lot's going to be ours, and we're going to maintain it and maintain the fencing, the security, and all that stuff. So we're in the ground or the pavement or something right now. So basically, they're just going to be using it, but we own it and all that. Correct?
We own it, but I remembered something in the bid specifications that they would be responsible for security of it. And is that correct, Chief?
That's correct.
So what are the tow agency's responsibilities as it comes to 500?
So they're going to be responsible for keeping it clean. Like, and if you would have seen the current lot that they maintain right now, it's night and day compared to what we have right now.
Okay, so with the fencing and the requirements to repair that area, is that something that we would be responsible for, or is that something that the impound company will be taking care of?
It's something that the impound company is going to take care of.
Okay. All right. If anything further from council? Then I will open it up to the citizens talking specifically in reference to this.
I'm sorry, Your Honor. I have a question.
Yes, go ahead.
Will the new contractor have an office there at 500 Southfield? I guess I'm curious as to how that's going to work for the residents or for those who get their vehicles impounded.
No, there won't be an office there. But their office is only a mile from our border. It's not far at all.
Well, Chief, how would you envision that to work? Somebody getting their vehicle out on, say, a Saturday morning. What would be the process?
They go down, pay their fines just like they do here, or, our current situation, and the driver will come down and release the vehicle.
Where would they be paying the fines at the police department?
We haven't worked that out yet. We could have it set up where they pay it there, or we could have them go down to their current office.
Okay. All right. Councilwoman, does that?
Yes, thank you, Your Honor.
Okay. Anything further from council?
Your Honor, one final thing. I know we're kind of prolonging this, but I just want to make clear one item.
Yes, sir. Go ahead.
Chief Waters, this potentially could save us $45,000 a year, right? Having this lot on 500 Southfield, right?
That's correct.
All right. Thank you very much, Your Honor. That's all.
Okay. Anything further from council?
Yes, Your Honor. I question, and there was several things now that come up that we're going to find out a little bit later. The fencing, how they're going to pay, how they're going to get their car. I think this should have been thought out and brought out before we voted on this, rather than putting it on the back burner. I just want to bring that thought forward.
Well, this is a wording of the bid. This isn't the specific contract that we will be signing. Those odds and ends and things can be taken care of in the language before it's signed. I would think so anyway.
Can we get copies or so that we know all of this before the contract goes into effect?
I would think so. Before the clerk and I sign it, it can be be reviewed or approved, or just before it is signed, we'll have it to council so that they can review it.
Thank you.
All right. Further discussion from council. All right, then we will open it up to citizens, specifically on this resolution only. Citizens are advised that you are limited to 3 minutes for this discussion. And we had who was it? Was that Alex? Was that you that wanted to?
I'm the general manager for Rusto's Towing.
Okay, sir, go ahead.
Hi. Thank you for allowing me to speak tonight. We've been towing for the Dearborn Police since 1974.
But I need your full name, sir. I'm sorry.
My name is Alexander Gavrila.
Okay, very good.
I'm the general manager for Rusto's Towing in Dearborn.
Okay.
I wanted to thank you for allowing me to speak tonight. We've been doing the Dearborn Police Towing since 1974. And I was just wondering before it went to vote if council had any questions about my proposal or any advice what I could have done to make my proposal stronger to serve the city of Lincoln Park and its citizens.
Okay. Does anyone of council have anything for this gentleman?
You did that. Go ahead.
I was just going to say, Chief might be the better person to respond to that question.
Well, I think that he's probably had an opportunity to speak with the chief. I would imagine. Okay. Is there anything else, Alex, that you wish to bring up?
Not at this time.
Okay, very good. Thank you for your bid. Is there any other one resident that wishes to be heard? Okay, hearing none, then we will then go. No further discussion. Then clerk, call the roll.
Councilpersons Kelsey,
Yes.
Higgins,
Yes.
Reading,
No, previously this company sued the city of Lincoln Park, and therefore I'm voting no.
Parkinson,
Yes.
Ross,
Yes.
Salcido,
Yes.
and Mayor Carnes.
Yes. So the next item that we have is, I think Mr. Gotch is on the call, or he was just a second ago. Sir, do you wish to make a comment or to be heard?
Yes. I just wanted to say I'm Michael Gosh. I'm the president and owner of Gosh & Sons Towing. And I just wanted to take the time to thank the mayor and the council, Chief Waters, Lincoln Park Police Department. And I look forward to providing towing service for the city of Lincoln Park. If you ever have any questions or concerns, don't hesitate to reach out and call me. Or if you'd like to take a tour of our operation, you're always welcome to stop by our office. And I'd love to show you around and show you the different pieces of equipment we have and the capabilities of our towing service.
Okay, sir. Thank you.
Thank you.
And good luck. Chief, I do have. How is the transition going to work? You have another month remaining on the contract with City Towing? We have.
Yes, sir.
And you're going to. And there's still going to be vehicles. There's still going to be vehicles that are there on that property. So, well, I'll leave that to you. All right. Our next item we have is resolved that the special event permit number 5 be approved for the Great Pierogi and Polish Favorite Drive Up to be held in the municipal parking lot at the Community Center, 3525 Dix, on September 27, 2020, from 10 a.m. to 8 p.m. under the following conditions. 1. Participants and vendors must comply with Executive Order number 2020-147. 2. Subject to cancellation if required by order of the Governor, per the recommendation of the Police Department. Executive Order 2020-147 states any individual who leaves their home or place of residence must wear a face covering over their nose and mouth. A, when in any public space. B, when outdoors and able to consistently maintain a distance of 6 feet or more from individuals who are not members of their household. Fee paid and insurance filed.
Support.
I'll move.
There we go. All right, discussion?
Yes, Your Honor. I still have some questions. I read through their letter that, where they gave descriptions of everything, and what I still would like to know is, are we providing them electricity or are they using generators? That's one. And then are we opening the community center to allow them access to restrooms? And then 3, they said that they provided documentation of their insurance. So I would like to know if it's not in the council packet, so, wherever it belongs.
I have it.
Okay. I wasn't sure.
I have it. The $1 million policy, liability insurance.
Okay.
Required for every special event permit.
Okay. And then I do have another question also. I know that Chief Martin responded, but has the police chief looked over the event? He has.
Yes, I emailed you earlier. I don't know if you got it, but I looked at it. We approved it. It didn't appear to be any different than any of the other events that were over there. So we didn't see any issues with it.
Okay.
And I wouldn't think that the restrooms would be open. I mean, they weren't open for the food truck event that was earlier in the year. So.
Oh, Mayor, the community center might actually be open because under the governor's orders, ice rinks were allowed to open, and Dennis has been putting the ice down. I do believe he's hoping to open this coming weekend, for the organized sporting activities is allowed under governor's order. So they may just be open.
Well, I would restrict it to just participants, to those that are taking place in the activities. If you open it up for the people that are driving through, there's no way that they're going to be able to keep the restrooms clean and safe for the things that. There's no way that we can, under the current orders, make it safe for people to go through. So I would suggest that you'd have somebody at the door that is looking, that maintains the people that have a right to come in, everybody else, sorry. In the other organizations, as I read through this letter, they have paid to $1,000 to $2,500 for the purpose of having their event at these sites. But there's no they're not paying